Good morning, everyone. Welcome. We are pleased today to be joined by colleagues from the International Court of Justice. We have Judge Abdulqawi Yusuf, the President of the International Court of Justice, and Philippe Gauthier, the Registrar of the Court. So we will begin with introductory remarks, and then, of course, we will open the floors for questions.
Thank you very much. I am very happy to address the press today. As you may know, this is the first press conference held by a president of the International Court of Justice since the year 2000. So we are not a talkative lot. We do not communicate very much. We let our work and our judgment speak for themselves. And I'm quite sure that you are acquainted with all of them. We are not also very often in New York. We are here this week because of the International Law Week. And during this annual visit to New York, the president of the ICJ addresses the General Assembly and reports to the General Assembly. I also have normally a dialogue with the Security Council, and I will do that on Thursday. I also address the Sixth Committee of the General Assembly, which is the legal committee. And I take advantage of our presence here to meet with the Secretary General and with other senior officials of the organization because we do not see each other very often, and we try to take advantage of our presence here to brief them and to exchange views on them and to bring them up to date on the activities of the court. I'm quite sure that you are acquainted with the background of the International Court of Justice. I don't want to go too much into details about the court. The court is the principal judicial organ of the United Nations, alongside the General Assembly, the Security Council, and the Economic and Social Council. And the court is the successor to the Permanent Court of International Justice, and it has inherited the statute of the Permanent Court of International Justice, a statute which actually was approved in 1920. So next year, the statute of the court will be 100 years old. And for 100 years now, states have accepted the judicial settlement of their disputes. It has not been an easy process. It's not easy for governments to submit their sovereignty and issues relating to their sovereign rights to an independent judicial institution. But this is what has been happening very often in the last, especially 20 years, and I will tell you why in the last 20 years. The court has two functions. The first one is to settle disputes between states that have consented to its jurisdiction. So the element of consent is very important, and I hope you keep it in mind. The second function of the court is to provide advisory opinions on any legal questions referred to it by the other organs of the United Nations, especially the General Assembly and the Security Council, or by specialized agencies authorized to seek such an advisory opinion. Since the establishment of the court, and the court started its work in 1946, 177 cases were brought to the court. 148 of those 177 cases were contentious cases, which means they involved disputes between states, and 29 requests for advisory opinion from UN organs or specialized agencies. The cases brought before the court concern all types of disputes between states. They relate to diplomatic and consular relations. The environment and cases on the environment have been increasing lately. The interpretation of bilateral or multilateral conventions, responsibility of states for an internationally wrongful act, use of force, armed conflicts, territorial and maritime boundary disputes, jurisdictional disputes between states, immunities and privileges, human rights, and investment-related disputes. So all kinds of imaginable disputes between states. Before a dispute arises, states usually accept the jurisdiction of the court, either through a declaration under Article 36 of the Statute of the Court, and there are 74 states that have accepted the compulsory jurisdiction of the court. The latest declaration was made a month ago by Latvia and deposited with the Secretary General of the United Nations. They also can accept and do accept the jurisdiction of the court through compromissory clauses included in multilateral conventions and in bilateral conventions, in bilateral treaties. And there are 354 bilateral and multilateral treaties which contain compromissory clauses that confer jurisdiction on the court. And it is actually most of the cases brought before the court are based on its jurisdiction under compromissory clauses. During the first 45 years of its existence, from 1946 to 1990, the court has dealt with 60 cases. But in the last 20 years, the court has also dealt with 59 cases. So you see that the docket of the court and the cases actually that have been submitted to the court in the last 20 years has doubled as compared to the previous years. We believe that this is due to a better knowledge of the jurisprudence of the court. We believe that it is also due to the confidence and trust that is increasingly placed on the work of the court. We believe that there is more predictability and stability with regard to the jurisprudence of the court, and therefore states can rely on the manner in which the jurisprudence and the judgments of the court will be rendered. And in the last 4 to 5 years, the docket of the court has actually been full. Full in the sense that we are a very small court, despite being the principal judicial organ of the United Nations. And although we continue disposing of cases, and every year we try to deal with as many cases as our modest structure can allow, because we have an extremely modest structure. We have a staff of 116 staff members, and we have a budget of $23 million US dollars a year. It is the smallest budget of any judicial international institution, but we believe that we have always been cost efficient, and therefore we have been rendering our services on the basis of this small structure. And although we dispose, as I was saying, of cases every year, 5 to 6 or cases on average, new cases keep coming to the court. And at present, we have 16 cases pending before the court, which involve states from all over the world. These 16 cases involve 26 member states of the United Nations, and 5 of them are European countries, 6 are African countries, 9 are Latin American and North American countries, and 6 are Asian countries. So as you can see, states from all over the world and from all the continents have cases before the court. And the court actually is dealing and has dealt in the past year and has among it also these pending cases relating to all the hotspots and conflict zones around the world. And therefore, we try to do our best to contribute to the peaceful settlement of all these conflicts and disputes. And we believe that we have done very much in terms of contributing to the reduction of tensions and to the resolution of conflicts. And we will continue to do that. So with that short introduction, I think I will take your questions, and I'm ready to take any questions you may have. And I thank you. So.
Excellent. Thank you so much. Please introduce yourself and the media you represent. Yes, go ahead.
Thank you so much, Mr. Yusuf, for allowing us this opportunity on talking to you on the quite different cases that are of the interest of many parts of the world. Just want to follow up on two cases that are of the particular interest of Latin America. First, the maritime dispute between Colombia and Nicaragua that's still ongoing. The last thing that we saw from that case was documents coming last March from both Colombia and Nicaragua. That was the last day that it was set up for them to be able to present some of their arguments. And in this time, in particular, the government of Colombia has contested the jurisdiction of the court to take up this case. So can you walk us through a little bit on how is this process going? Have you received all of the documentation? Where are going to have new rulings, new proceedings, something additional, or what's coming on this process? And then the second follow-up is also on the jurisdiction, but on the dispute between Venezuela and Guyana over the Essequibo. So there is also a dispute going on there that right now that's a process that has been complicated a little bit because of the political situation in Venezuela. So could you also tell us a little bit about on how this case is going? Thank you.
Thank you very much. Before answering your question, let me tell you about the latest case that we have actually received from Latin America. And it is a case which concerns a dispute between Belize and Guatemala. And what is interesting about this case is that for the first time in the history of the court, the two governments, before submitting the case to the court, decided to submit it to popular referendums and asked their respective populations, should we submit our 200-year-old dispute to the International Court of Justice for settlement, for peaceful settlement? And we are extremely proud to be able to report that the populations of the two countries have overwhelmingly approved it and given their consent to the submission of this dispute to the International Court of Justice. And the dispute was submitted to the court in May 2019. And we are going to deal with that dispute. With regard to Colombia and Nicaragua, there are two cases that have been going on actually for quite a long time. And the issue of the jurisdiction has already been dealt with. There is a judgment of the court as far as the jurisdiction is concerned. Now we have to deal with the merits as far as the two cases are concerned. And both countries have now completed the submission of their memorials, counter-memorials, their written pleadings. And therefore, the court will have to schedule hearings on both cases in consultation with the governments. But, of course, we do not try to push too much the governments. We let them also, because we have now a very high caseload for the time being at the court. And therefore, we try to schedule cases for hearings as much as possible and as quickly as possible. But we have not yet fixed a date for either of those two cases. With regard to the case between Guyana and Venezuela, this is a case that has actually been referred to the court after 50 years of mediation between the two countries by the UN Secretary General. And we believe that successive UN Secretary Generals have tried their best to settle the dispute between the two countries. And finally, they have advised the countries concerned to take the case to the International Court of Justice. I think it is. So it was submitted to the court. Venezuela has, in a way, challenged the jurisdiction of the court, and therefore the court has scheduled it for early next year. The hearing is on jurisdiction on that case, and we will most probably have a hearing on the jurisdictional aspect of that case in the first 6 months of next year.
Just a quick follow-up on the Colombia-Nicaragua case. Any possible timetable on the scheduling of the
Not
hearings?
Not yet, yeah.
NHK.
Thank you, President Yusuf. My name is Sato from NHK TV. Thank you very much for this presentation. I have two questions to you. One is about a overall situation which you are treating. You mentioned about 16 new cases now has filing. And is there some trend changing what you are mentioning about conflict? For example, is there any climate change related dispute, for example, to compete the water resources? Do you see that any recent characteristic of the dispute in general? One more question is about Asia you are mentioning about. As long as my understanding that Japan has not called for the case to the ICJ yet, but how do you see the territorial issue and legal dispute between Japan and South Korea? And thank you.
Thank you very much. I think that disputes between states are always more or less disputes which concern their respective jurisdictions or their respective rights. So it depends which rights a state may be asserting and which jurisdiction a state may claim with respect to a space. The rights can relate to the protection of consular officers, diplomatic officers, the sovereign rights in certain maritime spaces like a economic zone, territorial sea, etc. The rights may also relate to the rights of individuals who have the nationality of a state, etc. Of course, we have also cases which concern the use of force. We have cases which concern delimitation of maritime and territorial disputes. So you can have all kinds of disputes, and we have, as I said, an increasing number of cases on environmental protection, and they keep increasing now, of course, and it is natural that they should keep increasing, and I think that states have a lot of confidence in the court because the court has actually a trailblazing experience and jurisprudence with regard to environmental issues. And the court has even recently issued a judgment on reparations regarding environmental damage. And it is the first time that an international judicial institution has issued a judgment on reparation with respect to environmental damage. With regard to your second question, we have a number of cases from Asian countries, and the court, for example, has issued only in July a judgment concerning a dispute between India and Pakistan, which was a very delicate and sensitive issue because it concerned the life of a person who was sentenced to death in Pakistan, and it created a lot of tension between the two countries. And we are happy that the judgment of the court has contributed to the diminution and reduction of that tension since then. We have also two cases presented by Iran against the United States, as you may know. One case concerning the freezing of assets in the United States by Iran, and in the United States, the freezing of Iranian assets by the United States. And the other one concerning the recent sanctions imposed by the United States on Iran. But we don't have any cases concerning Japan and South Korea and the Republic of Korea. We had a case concerning Australia, Japan, on whaling, as you know. And that case was very satisfactorily settled a number of years ago. But we don't have any other cases right now involving Japan.
And just out of curiosity, you mentioned reparations on environmental damage. Where is that?
Costa Rica, Nicaragua.
That's it. Yeah. Yes, at the back.
Thank you. Abdulqawi with the Russian news agency UNWebTV. As far as I know, on the 8th of November, the court will deliver the judgment on the preliminary objections raised by Russian Federation, regarding the lawsuit of Ukraine against Russia. Could you please elaborate on that? How do you think, how long may take the consideration of this issue, of this lawsuit? How long will it take? How do you think? Could you elaborate on this? Thank you.
Once the court delivers its judgment on its jurisdiction, then we will be able to know, because I don't want to reveal here the contents of that judgment and tell you whether the court says that it has jurisdiction or whether it says it has no jurisdiction. But the follow-up to that judgment will depend on whether the court has jurisdiction and says it has jurisdiction, in which case, of course, the parties will have to continue with the merits phase of the case. But if the court says it has no jurisdiction, then the matter stops there. So you will have to wait until that judgment is issued on the 8th of November.
Thank you. My name is Tatira Junaira. I work for a daily newspaper from Zimbabwe called Newsday. I wanted to find out, I understand that you might have received a case or it might have been registered. I'm not sure if it's gone, actually be any case or not, but you might have received something about Zimbabwe, and if so, I wanted to just get details on that.
A case relating or involving Zimbabwe? No, we have not yet received a case involving Zimbabwe or relating to Zimbabwe's relations with another state. No, absolutely not.
Hi, good morning. My name is Carrie Newton. I'm working for Le Monde. Can we have a little quick follow-up on, you mentioned two cases involving Iran against the freezing of their assets by the United States and the recent sanctions. Can we have a time frame? Are you able to tell us what are going to be the next step on these cases, please?
With respect to the case on the Iranian assets, the court had hearings last year and early this year, and because the United States is challenged the jurisdiction of the court with respect to this issue. And the court, in its judgment on its jurisdiction, upheld some of the objections of the United States and rejected others. So the case will have to go forward with respect to those issues on which the court has declared to have jurisdiction. And we have consultations actually with the parties on my return to The Hague in early November to ask them how much it will take them to submit their counter memorial, and if they would like to have also a second round of replies and rejoinders. So we will have to consult the parties on that. With respect to the other case concerning the sanctions, Iran asked for provisional measures of protection. Those provisional measures of protection were issued by the court last year, as you may remember. And the two parties are now actually involved in the submission of their memorials and counter-memorials. And with respect to memorials and counter-memorials, because some of you may actually have heard what I would characterize as rumors that the court takes a long time to deal with disputes and that it can last for years, etc. I have to tell you that the issue of the submission of written pleading is in the hands of the states involved in the dispute. It's not in the hands of the court. For example, if I may give you the example of this special agreement through which Belize and Guatemala have brought the case before the court. They had already decided that each one of them will require 12 months to submit its memorial and then the counter-memorial, and then 9 months for the second round. So that takes you almost to 3.5 years, 4 years, and that is in the hands of the government. And when, for example, we have to deal with a case like the one between the United States and Iran, we have to consult them and ask them how much will it take you to submit your memorial. And a government may say 6 months, 9 months, and then the other government will also ask for 9 months. So that's why it takes time. But the case comes into the hand of the court once the hearings are held. So from the moment hearings are held, the case management is in the hands of the court. And from there until a judgment is issued, it doesn't take, on average, more than 6 to 7 months. And that is exactly what it takes for the court to issue judgments. So the rest is actually the process which is in the hands of the states involved in the dispute.
And just as a follow-up, never thought about changing this rule and giving a shorter time to countries to submit their memorials and counter-memorials?
You know that what is at stake is extremely important for states. And international law is not an easy subject matter. And many states actually do not have adequate resources as far as international lawyers are concerned, and they have to have recourse to outside counsel. And the circle of counsel and lawyers who are specialized in international law is rather limited. Yeah. So sometimes it is because of the counsel that the government will tell you that our counsel are extremely busy, and therefore we need 9 months, 1 year to prepare our written submissions. And therefore we have to show some understanding for that.
Yes.
Thank you, Maria Khrenova, TASS News Agency. So I'm not sure if you're following, but now there is a visa issue is discussed in the Committee of Relations with Host Country in United Nations. It's because some of the delegations, including Russian delegation, are not given visas on time to participate in UN events in New York. So some delegations suggested that this issue would be discussed in court between Secretary General and host country, as it's written in the procedures of this committee. So I wonder if there have been such precedents of courts between Secretary General and another country and a member state. If you believe this issue really can go to court, from legal point of view.
If it has to go to court, it will not be our court, because the host country agreement is between the United Nations and the United States, and unless it is brought to the International Court of Justice for an advisory opinion, which is very unlikely, I would say, it would have to go to perhaps the local courts here in the United States. But I would not really like to comment on that, because it's a matter on which we are not absolutely informed. And I know from experience, because I used it to be based here in New York a long time ago, that there is a host country committee which deals with such matters, and I hope they will be able to find a solution for that kind of problem.
Thank you, sir, for this briefing. My name is Oscar Bolanos from OMB Independent News, and my question is regarding the situation in Venezuela. 5 Latin American countries and plus Canada, and besides the denouncements by Luis Almagro from the OAS about the violation of human rights by the government of Venezuela. And are you following these denouncements, or what is the update on this? And besides, the people from Venezuela still live in the country because the crisis, the situation itself in the country. Thank you.
Thank you. My answer is simply no. We are not following, and we are not aware of the declarations you are talking about. Yeah.
And we will take one. Well, we'll take you two. Go ahead.
Yeah. Sorry, first, I do beg your pardon. I forgot to introduce myself first. My name is Alejandro Rincon. I'm from NTN 24 News from Latin America. And an additional quick follow-up on the Colombia-Nicaragua case. Has the court had the chance to examine the legality on the claims by Nicaragua on the continental platform that currently belongs to Colombia, and that is maybe part of the hottest contested part of the case right now? Have you had the chance to decide the legality of that Nicaraguan pretension?
Exactly, that is actually the matter you are referring, I'm quite sure, to the continental shelf beyond 200 nautical miles, and that is the matter which will be examined by the court on the merits when we move to that phase of the case in the near future, I hope.
And one last question. Yes, Sato.
Thank you, Christina. So my question is, sometimes that the Secretary General talking about multilateralism is in danger, and nation states is getting more intolerant and selfish. As an international judge, what is your perception of that today's world? It is more troubling or less troubling?
It is a very difficult question, I think, for a judge to answer. But let me tell you that as far as recourse to the multilateral institution, which is the International Court of Justice, is concerned, that recourse to the court has increased in the last few years, as I said earlier. And actually, we see an increase in the confidence and trust of states in the work of the court as a multilateral judicial institution. So it is possible that certain multilateral arrangements are under pressure, but the court is not one of those for the time being, and we thank God for that, and we are very proud of it. Yeah.
Judge Yusuf, thank you. Oh, Okay, one last.
No, it's not a question, just usually we do it in the beginning. Sorry, we're being rude on behalf of United Nations Correspondent Association. Thank you very much for this briefing, Mr. Yusuf. We really appreciate it.
Thank you very much. Thanks.
And thank you so much for being with us, and thank you to all of you. Thank you.
Thanks.